again?
640, 647,
640.
640, 647, 674. In 647, he takes note of the objective resolution, my lord, for arriving at, there is that additional factor. The Justice Ray, para 783, 297, 819.
Can you repeat, Mr. Dwivedi?
Justice Ray, para 783, 797, 819. Then Justice Jagan Mohan Reddy, 1121 and 1124. Justice Palekar, paragraph 1231. 1231. Justice Khanna, paragraph 1378. Justice Matthew,
Just repeat Justice Khanna's paragraph.
Justice Khanna, 1378.
Yes.
Then Justice Matthew, 1573, 1580, 1603, 1715. Then Justice Dwivedi, my lords, is 1876 to 1878.
1876.
1876 to 1878. That is 1876, 1877, 1878.
Mr. Dwivedi, paras 1876 to 1878 bind you completely.
Yes, you cannot take a different view.
So I'm not taking it. And then Justice Y.V. Chandrachud.
I should have realized what was coming.
1876. Your Lordship's noted 1904 also, my lord, Justice Dwivedi.
No, 1904.
Then Justice Y.V. Chandrachud, my lords, 2068, para 2068.
And what is the principle which you are relying on?
They describe what is a constituent power. So the power which enables amendment of the provisions of the Constitution, be it a derived constitutional power, it is the nature is constituent. The fact that it vests in Parliament or it vests in the President being in the head of the executive would not make a difference. The nature of power, it's certainly not similar to ordinance making power. Ordinance making power is specifically, expressly said to be having the force of the law made by Parliament. 123 and 213.
In fact, the ordinance making power would support your submission, because the fact that a power is not vested in Parliament, in this case the legislative power, the ordinance making power, is not dispositive of the nature of the power.
Yes.
It's not the institution which wields the power, but the nature of the power which is crucial.
That's right. I'm grateful. One has to consider the nature of the power, not who is wielding it.
So, for instance, one of the exceptions to the doctrine of separation of powers is the legislative power which is vested in the Supreme Court to frame its own rules.
Yes.
It's also regarded as legislative in character.
It is. And it is original, flowing from the Constitution, not otherwise.
Likewise, Parliament has the power to punish for contempt of itself.
Yes.
So that is, in that sense, not a legislative power. It's a judicial power which is wielded by Parliament. So according to you,
there is no absolute
370 itself is a constituent power.
Yes.
Because it's a power to amend the application of the Constitution to Jammu and Kashmir.
That's my answer. Then with regard, the other submission which I made was about recommendation. I will not repeat that why, my lord, recommendation should be considered as non-binding, but just to compare, my lords, Chief Justice had last occasion words. If your lordship looks at article money bill, of course, the lordship saw, my lord, but that's different, my lord. That goes to Rajya Sabha. Rajya Sabha expressly mentioned that Lok Sabha is not bound.
Yes.
So money bill provisions are 109 and 198. Then there is a disqualification provisions, my lord, that is article 101 and 192. Now please see 101. Though the word is not recommendation, the word is opinion. If there is an issue of disqualification, oh, I'm sorry, not 101, 103, lords. 103. I apologize. 103. One makes the decision of president final, but 2 says before giving any decision, I'm drawing my lord's attention to 2. Before giving any decision on such question, the president shall obtain the opinion of the election commission and shall act according to such opinion. Mark this last expression. So where they want that, my lord, if some other body, whether inferior or at par or superior, is not material, but of course it is disqualification and a decision given by the election commission. But they wanted that the president should have no other discretion left. He has to act. Now these words are not deployed in 373. Now similarly, when we come to finance bill, that is article 117 and 207. 207 is for the state. Sub-article 1 of 117, a bill or amendment making provision for any matter specified in clause A to F of clause 1 of article 110 shall not be introduced or moved except on the recommendation of the president, and a bill making such provision shall not be introduced in the Council of States. Now this is a perpetual provision, it was not a temporary one. And the proviso says, provided that no recommendation shall be required under this clause for moving of amendment making provision for the reduction or abolition. Now, very interestingly, the bill is to be placed by the cabinet, the Council of Ministers. And the recommendation is to be made by the president, which is also Council of Ministers. Now, this is relevant for Article 3. So our framers do contemplate situations where the Council of Ministers is at both the ends. At one end, it speaks through the president. At the other end, it's the framer of the bill and places it before the House.
And president is acting on the advice.
Advice was, in a way, it may appear to be superfluous because if the cabinet has to place it, straight away proceed because the cabinet and president in any case has to sign it and recommend. But the situations are different. Similarly, 117(3). A bill which, if enacted and brought into operation, would involve expenditure from consolidated fund shall not be passed by either house unless the president has recommended to that.
The reason why it was said that the president must recommend and not the council, so that's really what it means.
Yes.
Is because under Article 84, the parliament consists of the president and the 2 houses of parliament.
Yes, yes.
The parliament doesn't consist of the council of ministers because the council of ministers are all members of parliament.
That's right.
But the president is a part of parliament.
But all bills don't go through the president.
They don't, only money bills.
Only money bills. So, sort of, perhaps it was intended to be an additional precaution that the president may look into it, may perhaps exercise his power under Article 75, etc., to divert it. And
So you don't specify the Council of Ministers because they are part of parliament. Individually, they are members of parliament.
Absolutely. Correct. That's right.
So recommendation you have shown us 109.
Now kindly see 146(2). Now this is a case, my lords, which my lords were referring about the rules power of the court.
Yes.
Now this is not from a superior to an inferior or something, my lords. Here the approval is required because of financial implications. (146)(2), and for High Court it is 229(2). Subject to the provisions of any law made by Parliament, the conditions of service of officers and servants of Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for that purpose. Provided that the rules made under this clause shall, so far as they relate to salaries, etc., require the approval of the President. It can never be argued, my lord, that if this, supposing this proviso is deleted by the root of 368 to ensure greater independence in financial matters, will the main part die, my lords? Are they rolled into one?
Yes.
So the fact that the proviso ceases, the main part ceases, and one very great argument, my lord, Mr. Gopal Shankar Narayan had raised, drawing my lord's attention to the colon. In 373 also it exists, perhaps to suggest that they are rolled because there is a colon, therefore they are rolled into one. Every proviso in the Constitution of India, I have gone through, Lord, and there are several provisos in various articles. All of them, Lord, have a colon. And colon in grammatically indicates only an addition, nothing more. Every proviso, Lordship may see. In fact, in 146(1) itself, there is a proviso, colon. Nowhere your Lordship will find any other, a full stop or a comma or a semicolon. It's always colon. Because it's addition. Generally as a rider. The rider goes, the main part expands. So if the proviso goes, Lord, in 146(2), then the main part, the power of this court, Lord, will expand, no need for approval. And the last part of this section of my submission is that so far as Parliament is concerned, the CO 273 does not refer to 367, etc., or 356. It only says exercising the power under 373 and acts on the recommendation of Parliament. Now, Parliament, my lord, can come through the route which the Union adopted. That's one part. My learned Solicitor General has already submitted. I will not repeat at all, my lord, on that. I adopt that, my lord, and nothing which I say detracts from that submission. But an additional submission is, my lord, that the President means Council of Ministers, and Council of Ministers means collectively responsible to the Parliament. So, Article 53 read with 73 and read with 75(3). Say, my lord, Council of Ministers can go to the Parliament any time for its obtaining its views. So the fact that Parliament's recommendation has been obtained, Parliament is not a foreign body. And the parliamentary rules, Lord, any issue can be brought before the parliament, resolutions can be passed, the views can be obtained. So we need not go, Lord, in my referral submission, of course, that stands. But irrespective of that, independently of that, the obtaining of the recommendation is not foreign, Lord, to the exercise of power under 373. Because of these three provisions taken together. So
Can you come back? Can you reformulate that?
the submission is that Parliament's opinion, recommendation or views for exercise of power under 370 sub-article 3 can be obtained by the Council of Ministers on account of the provisions of Article 53, 73 and 75 sub-article 3. Since Council of Ministers is responsible to the Parliament, so it can always go to the Parliament. In fact, that's the best route to go to the Parliament because it's a big decision being taken. So the whole of Parliament is being taken into confidence. Instead of rushing through in an executive forum alone, there the voice taken together, both the houses, the voice of the people of the whole country is heard, including the member of parliaments of Kashmir, who are also represented in the Council of States. So therefore, CO273 is sustainable on its own. And one small aspect, Lords. Let's take the submission of the petitioners at the highest, Lords. What are they trying for, Lords? This permanence which they are seeking is for what? According to them, Lord, Sampath Prakash, sub-article 2 is already defunct. According to petitioner's submission, main part proviso rolled into one, therefore all of 3 is defunct. A, of course, 238 itself has gone, is defunct. B1, only, Lord, and B1 has a very narrow scope, Lords. Please have B1 once again. I have a slightly different take on B1. B1 is not for determining the matters irrespective of the list. What matters have been specified in the instrument of accession are to be determined by a reading of the instrument of accession itself. Nothing can be taken away from that. That is final, sealed. What B1 is limited to discovering which of the entries are corresponding to those matters. There are matters specified in the IOA. There are matters specified in the 3 lists, which are corresponding. It only discovers the entries. There is no power at all vested in the president to act in consultation to detract from the IO surrender. If defense is being surrendered, then it has to be exercised as per Constitution of India, wherever the power is. Only the entries has to be located. And that power cannot be controlled. You take away residuary power or do whatever. Subject matter of defense is surrendered by that, and therefore the central union government will exercise full powers with regard to communications, etc. Entry or no entry.
Because there may be more than one entry
Yes.
in the union list or concurrent list, which corresponds to a head in the instrument of accession.
That's right.
The instrument of accession was prepared at a time when the constitution was yet to be framed.
Yet to be framed.
Therefore, it used broad expressions: defense, external affairs, communications, and it had various subheads, as we saw yesterday. You showed us that.
Yes.
For instance, defense. Now, just take one example only. Defense.
Yes.
In the union list covers entry 1, Defense of India. Entry 2, Naval, Military and Air Forces. 3, 2A, deployment of any armed force, which came in the 42nd Amendment.
And
4,
arms,
Naval, Military and Air Force works. 5, arms, firearms, ammunition and
Yes.
explosives. So it was basically what the president had to do was look at the entries in the lists and see which of these entries corresponds to what the IOA has said would be the domain, would be the domain of the Dominion of India.
and consultation came in for a reason, historical reason, because when cabinet mission plan was being considered, then primarily Nehru ji and the Congress itself wanted to keep it loose. And they were all the time contending that these expressions are only categories of entries, matters. It's not one matter, defense. There's a whole lot of other things. For if you want a defense, you will need finances for the defense. So he was interested in expanding and centralizing, more power to the center. So there was one thing that therefore you consult, get their views, it's okay. So consultation is a weak expression, it doesn't bind the president at all. However, that's the difference which I pointed out, that this is only to discover the correspondence. But it cannot detract from the surrender in the IOA. Now, since that has been done, this is also defunct.
Just 1 minute.
So what survives is B2 and D, proviso 2. Even the first proviso, correspondence.
Is what survives according to you is B2.
And D, proviso 2. I'm taking the case of petitioners, not according to me, but
No,
according to
We are,
them.
you are testing their hypothesis.
Yes, we have to test, Lord, what is it you are gaining, Lord? What are you wanting, aiming at? You seek permanence for B2 and D, P2, proviso 2.
Sorry, just come again. B2 and D, proviso 2.
Yes. And over the course of years, almost all institutions of the union have been applied. Very little remains in B2 and D2. So permanence for that. It really leads to the principle, my lord, that we should avoid absurdity, my lord. It's a reductio ad absurdum, my lord. My lord, the second vital question which arises with regard to 370 is, what is the status of the Jammu Kashmir Constituent Assembly and the Constitution of Jammu Kashmir? If I may use JKCA and COJK. And there are two contending thoughts. Once again, the choice is between these two.
Yes.
We are saying that the source for creation and disappearance of the JKCA and the COJK, Constitution of Jammu Kashmir, is Article 370 itself. Whereas the petitioners contend that the source for these two bodies flows from the crown of Hari Singh. That is to say, residuary sovereignty, remnant sovereignty, or internal sovereignty. Three expressions have been used by three different councils.
What are the expressions?
Residuary sovereignty, remnant sovereignty, or internal sovereignty.
Shared sovereignty.
Shared, which my friend Nitya Mlod used, has a different connotation. We are all sharing, Mlod. We are all co-sharers of sovereignty. Every individual citizen is a co-sharer. I have no problem with sharing of sovereignty.
Residuary sovereignty.
We all share, Mlod.
Remnant sovereignty, and the third?
Internal sovereignty.
Internal, yes. Mr. Dr. Dhawan said that.
And from this idea of remaining balanced sovereignty, there was a further, Mlod, concept introduced, bilateralism or compact. There are two sovereigns now, one remnant and one the main sovereign. So the two sovereigns are talking to each other, whispering to each other, and all that theory, Lord, and compact and bilateralism emerges. So the choice is between these two, Lords. If you accept that some sovereignty remained after the signing of the IOA, and some sovereignty remained after agreeing proclamation, Lord, that of Yuvraj Singh, that relationship between union and the state will be defined by the Constitution of India as applicable to. Then that expression is very important. You don't have to go out of Constitution of India. It is defined by the Constitution of India as applicable. Whatever it may be applicable, but it is to be found within the terra firma of the Constitution of India. This methodology, Milords, just let us have a look, Milord, what is the Constitution of India telling them? Note two things, Milords, which are expressly in 370 first. The first is the explanation. And the explanation applies to the whole of the article, not only sub-article 1. In terms, it says, for the purpose of this article, the government of the state means so and so. What is it doing, my lord? One, it is substituting the Maharaj for Maharaj acting on the advice of Council of Ministers. So the monarchy is dead. The popular rule came, my lord, when the Maharaj, my lord, came, my lord, when he was neck deep in trouble on 25th of October 1946, when the war was there, everything was virtually being lost. He had virtually nothing left for sovereignty, my lord. And it is on that crown, my lord, which they are, the sinking crown on which the petitioners' submissions are banking. However, that crown also, my lord, Nehruji first said that you release Sheikh Abdullah and popular government. He was released, he was made the Prime Minister, and on his advice, it was not simply Hari Singh, it was both the popular government and Hari Singh, my lord, who agreed to the accession. So the people's voice was also there. And the explanation leaves no room of doubt that the Maharaj is not to act on his own view, opinion, discretion, but act on the advice of Council of Ministers for the time being in office. Second, my lord, even the Maharaj has to be recognized, that person who is recognized by the President of India. So when Yuvraj, my lord, issues the third proclamation in 1951, that is after the Constitution of India came into force, he was acting on the advice of the popular government in terms of the explanation to convene, to constitute and convene the JK Constituent Assembly. The next question would be, my lord, what is it? For what purpose are you constituting? And the purpose is spelled out by sub-article 2. So the Constitution envisages that this assembly is for the purpose of framing the constitution of the state. The third thing, my lord, is in framing of the constitution, the JKCA is does not enjoy the freedom which the Constituent Assembly of India had. It was bound by several things. First, it was bound to frame the constitution in a manner that the sovereign democratic Republic of India, that's not adversely impacted. And at the moment, I'm not relying upon the doctrine of basic structure which came later. But even as it stood in 1950, 26th of January, this constitution of JKCA could not detract from it and has not. It had to ensure justice, liberty, equality, fraternity. The contours of law making are specified on account of the sheer accession. It was also bound by Article 1 it could not declare that we are not the federal unit of India. And it accepts in that dictat of the Constitution of India in Section 3. That's not their own framing. That's they are bound to do it. Next, my lord, they could not therefore say that any part of their territory will not form part of the union territory. That is 1(3). They could not also say that every person domiciled in the territory of India, and your lordships have held, my lord, I'll give that judgment where lordship said there's only one domicile. Every state does not have a domicile. Nobody can say I'm domiciled in UP or Tamil Nadu or Bihar, etc. So they could not say that the people who are, that is the permanent residents of Jammu and Kashmir, will not be the citizen. And they accept that, my lord, in Section 5. That's not a gift of JKCA. That's the gift of the Constitution of India and the dictation of the Constitution of India to them. The same applies to the fundamental rights. Every citizen, see the concatenation and the connection between these provisions. 1, 5, Part 3, which says every citizen. In fact, some of the fundamental rights are broader, but 19 specifically citizens. So these rights could not be denied, and therefore they rightly will not follow it, the dictat will not, and put it in Section 10. Even if it was not there, my lord, they would have enjoyed these fundamental rights under the Constitution. And neither the president acting, my lord, under 370, nor the authorities, my lord, who are giving concurrence or consultation or recommendation could say that apply 370. That's not the purpose of the recommendation, is very narrow. Continue operation, don't operate, or operate with some little modification. So therefore, my lords, these fundamental rights, etc., and they also could not say, and they have wrongly not gone into that in my humble submission, when they said that Article 136 initially of the Supreme Court's power will not apply to Supreme Court. They could not say that. Because in the accession, my lord, they have said we accept the Governor General, which will be President now, the federal legislature, that is the Parliament, the federal court, that is the Supreme Court, and other authorities, my lords, who are under the Constitution charged with certain functions. The power to fix terms does not mean, my lord, that you take away the power of these authorities under the Constitution. But things have been happening, my lord. 35A has also come, 136 had gone. That to deprive 136 to the people of Jammu Kashmir, my lord, is a huge denial to them. So in short, my lords, the framework of the Constitution of India, and when we look at JKCA, we find that the entire JKCA is a reflection, my lord. There's nothing peculiar in that, my lord. What is peculiar is 147 when it says that you can't amend the Constitution. There are restrictions. Likewise, Section 5 says that whatever be the Parliament's power under the Constitution of India. So throughout it follows the diktat and respects the Constitution of India, and there is very little in it which is different. This methodology which has been adopted by the Constitution of India for the formation of JKCA, its convening and its enforcement, in my humble submission, is very akin to the juristic concept of devolution of powers. Devolution of powers. The Constitution has devolved power on the Yuvraj, then acting on the advice of Council of Ministers, to convene for the purpose of framing the Constitution in accordance with the broad format, as I pointed out. It's not an independent power like the Constitution, Assembly of India. I'll give to your Lordship, in view of the time constraint and these two judgments, this concept is frequently applied, Lord, in United Kingdom. Scotland, Northern Ireland, Wales, all of them are enjoying devolved powers. The Parliament of UK is considered to be supreme. There, of course, that is somewhat different in the sense that the law made by UK Parliament for Scotland specifies not their Parliament. So we have Scotland Parliament also, Northern Ireland Parliament also, and the Wales Parliament also. So it doesn't matter that you call your person Sadar-e Riyasat or Prime Minister or Chief Minister, the stature doesn't expand by these expressions. The stature will depend upon the nature of power you are exercising. It doesn't equate with the power of Prime Minister of India, even if you call them Prime Minister. Yeah, psychological and emotional reasons apart. So the two cases, my lord, they are not on record, so I will not place it, my lord. The time bar is there. I'll just give the reference and paragraphs through your lordship, my lord. I would not admit it. We did send it, my lord, but it's not admitted, so it's up to your
What
lordship.
are the two cases? You can give us a citation.
I am giving the citation. 2002, Volume 1.
What's the name of it?
The name of the party is In Re Scottish Independence Referendum Bill. In Re Scottish Independence Reference Bill 2022, I'm sorry, 2022, UK SC 31.
You repeat the citation again?
Paragraph
Can you repeat the citation, Mr. Nehru?
2022
Yeah.
UK SC page 31. Para 76, 77, 82, 88 and 90.
Yes.
And how can you just sort of summarize in a sentence what the principle is?
The principle was, my lord, that in this case, they wanted a second referendum. Sorry, my lord, when the Brexit was happening, then they wanted to continue relations with Brexit. So it was impinging upon the sovereignty of the parliament, my lords. In that context, my lord, they have discussed this devolved powers. And they say that the parliament gives the power and parliament can take the power, it can modify the power, so the parliament is. So this power is also a devolved power of a different kind, of course, because it's more general. It's not itself framing like other states, what they are to do, they don't have the list to, so it's a little more. So that's the departure. So you have the psychological satisfaction of.
And what is the second judgment?
Then the other is 2000. This is case is UK withdrawal from European Union. 2019, 2018, UK SC 64.
2019 or 18, you said?
18,
Yes.
UK SC, page 64. Paragraph 12, 13, 29, 53, 61 and 63. Now, in this context, Lords, kindly just keep my written submission open, Lords. It's in the combined. I have tried to extract things there, Lords, so that I don't have to request your Lordships to open the document as far as possible, Lord. The other aspect, Lord, Nehruji himself says that the idea of having a constituent assembly for framing a constitution for the state emanated from the government of India. And that is, the Lordship will find in para 128, page 44 of my submission.
It's in which volume?
Well, this the combined compilation, volume 3 written submission.
Volume 3 is Mr. Solicitor's, no? Mr. Tushar Mehta's, right?
All
It's in
submissions
that.
are there.
Oh, I see.
All submissions are there only.
Right, but that's in volume 4. We got it. Yes, we got it.
It starts at page 271. Oh, sorry.
Volume.
Kindly come to the last 8 lines, notes.
Of which page?
It will be, notes, paragraph 128 at page, PDF might be 44 minutes.
Not 44.
Para 128,
Of your submissions?
submission.
Where do your submission start from? Which page?
They start at page 271.
Yes, it
What's
starts
your
from
internal page?
271,
What's your internal page?
page 44.
That will be about 313, I guess.
PDF 316,
What's the paragraph number?
128.
Yes, it's page 316.
Okay, hold on to it.
If towards the middle, you shall find, thus the monarchical power had disappeared. The Lordships have got this one? Hello, Justice
Yes.
Surikant.
Yes,
One second. What page is it?
Hello, Justice Gawai has got this?
Yes, para 128.
Yes, sir. I'm grateful.
Judgment? Para 128 is from a judgment, it appears.
No.
It says Sri Nafri Learned Senior Counsel.
That was, we are responding to the submission of Mr. Nafri.
Oh, all right.
They were all saying, that the Maharaj has found how he will form the JKCA and
Let's quickly go through that.
Lordship may have the middle, Lord, only.
Yes.
Thus, the monarchical power had disappeared with the advent of the Constitution of India. Maharaj Karan Singh merely.
Just one second.
I'm so sorry.
Monarchical power.
Yes. Thus, the monarchical power had disappeared with the advent of the Constitution of India. Maharaj Karan Singh merely executed the mandate of the Constitution of India embodied in Article 370. Secondly, speaking in the Lok Sabha on 26th of June 1952, soon after the proclamation of Maharaj Karan Singh dated 1/5/1951, Prime Minister Shri Jawaharlal Nehru said, "So the government of India and others put it to them, to the Maharaj and Sheikh Abdullah, as soon as he came out, that this matter must not be hurried. And it was our idea then that a constituent assembly should be elected in Kashmir quickly and as soon as possible to decide about these and other questions. So we advised them." So in view of 370, and perhaps not because of the international situation regarding Kashmir, which was developing, the government of India wanted that it should be convened, there should be a ratification of accession and all that. That's the idea came from here, not coming from them, my lords. What was Maharaj Hari Singh wanting, lords? He contemplated a national assembly he was still dreaming of independence. So he was thinking that when the whole of the POK, etc. comes in, then there will be plebiscite and then we will decide whether to accede or not. And that's the mischief which Mountbatten played when he wrote reply letter when he said that our policy of our government is, who is he to write, my lords? He is bound by the Government of India Act and the adaptation order, which says that once the Governor General accepts the accession is complete. And Indian armed forces are there driving back the people who had come inside to grab Kashmir. But he writes a letter, my lords. Governor General directly writing a letter. Policy of our government is, that letter has no meaning. Mr. Sibal referred to that letter to draw some sovereignty, my lord, etc. That still looks, sovereignty remained. Accession was still a dispute, still to be settled. It's not final. So where are we to go, to what extent, police? So what Hari Singh contemplated was completely different. What Karan Singh proclaimed was, our relation will be defined by the Constitution of India as applicable to you. The two different contrasting expressions used there.
What remains, Mr. Vedi?
Because a lot remains. Because we will, sum total, we will not be crossing the boundaries, but these aspects need to be placed before our lordships and have not been placed. Now, my lords, the question is, what did they refer to? Mr. Sibal started from the cabinet mission plan, return of paramountcy. Then, when the British left, all Indian states became independent. They were free, my lords. Many felt so. From there, my lord, the sovereignty element is being derived. What is forgotten is that cabinet mission plan was again a British device to frame a larger Pakistan within India. Three groups. The central provinces, Group A. Northwest, Group B. Assam and Bengal, whole of it, Group C. Something which even Muslim League did not demand, the British were framing. Because they wanted a lot to control the two frontiers for geopolitical reasons. They want bases at both the ends. So they came with this cabinet mission plan. And it was basis was that parties are not agreeing, therefore we are presenting arbitrators. And what was the dispute? Well, the first great interpretative exercise where the fight was, are these groups frozen? They provided an expression that once each group will frame a constitution, and once the constitution is framed, then the provinces which are part of the group may decide to remain or to go out of the group. Then the leaders who were leading on the side of the Congress, they said, no, these groups you may form, but once it is formed, then the provinces need not wait. And they will, so the huge fight not about the frozen character of the groups. And the other issue was parity at the center, weak center and parity. Parity, Congress, Muslim League, and the princes, three. So who controls, Mulad? As we say in the Bandarbat, Mulad, the British becomes the arbitrator. There will be stalemates on every issue. Now this creates a larger Pakistan. The option was partition. Now this went on. Our constituent assembly was constituted under the plan. So we decided to work out the plan, but without being bound by the cabinet mission plan. And it was made very clear by our leaders that once constituent assembly starts, then what it decides is not your concern. It may choose to destroy the groups also. In fact, the leaders were called to London also, and they said it may be referred to federal court in case of dispute, but our acceptance will remain qualified. Not 26th, 9th of December, 1946, our Constituent Assembly started functioning. Temporary chairman, Dr. Rajendra Prasad, then objective resolution placed on 13th of December, debated, accepted and adopted on 22nd January 1947. All this is happening before 15th of August. Then they proceed to form a negotiating committee to negotiate with the states and based on the cabinet mission plan which the princes had accepted. Please note section 8 of the India Independence Act recognizes that the Constituent Assembly of India is that which began functioning on 9th of December 1946. There may have been a withdrawal of the British legally and physically on the 15th of August, which we celebrate as our Independence Day. But our independence is not a grant of India Independence Act. It is a result of the long drawn people's struggle. That's why the we the people has come. There are some observations in Justice Beg's judgment, Lord, in Indira Gandhi's case, which the other side relied, but I found some other observations which say that independence was granted by the India Independence Act. India Independence Act, what does it do? There shall be two dominions. It is partitioning and providing an interregnum arrangement what will happen in between. Namely, the Government of India Act continues with adaptation, etc. And that the Constituent Assembly will also function as the Legislative Assembly. That is also provided in. So it's a machinery act, a transition act. It's not an act which grants us. They say dominion. Somewhere, my lord, expressions of dominion are still lingering in our constitution. My lord, the Attorney General and the Solicitor should take care that they are deleted. There are some provisions where still, my lord, the word dominion continues. But we did not accept the dominion. Here comes the role, my lord, of the objective resolution. It said we are adopting an independent democratic republic. So the negotiation with the Indian states are based on the concept of republic. And since our assembly continues based on that objective resolution from 9th of December 1946, therefore, this republican character is the basis for accession. This is important for the reason, if you compare Section 5 and 6 of the Government of India Act 1935, it talks of a different kind of federalism, a federalism under the imperialism, a federalism under the crown, and a federalism which will be triggered by the decision of His Majesty. Provided more than half almost of the princes agree then to come in. So a different kind, accession, signing of the instrument of accession under the Government of India Act is different from signing of the instrument of accession under the Constitution of India in the making or under the Government of India Act as adapted. My lord said, notice the expression union, unity. There is some very vital document. Now, my lord, government has released several volumes of transfer of power, having about total of 13,000 pages. I was able to get this document, which is annexed to my written submission. Kindly have a look at that. It completely changes, and all these documents were not present, my lord, in the earlier exercise relating to 370. PDF paper. PDF page 327. Lordship has this?
Yes.
Lord Justice Call has this?
This volume 11, the Mountbatten. Is that what you're reading, in extra 2?
No, I'm on the same written submission note which I was reading
Yes,
earlier.
Yes, yes.
That's the tran-
327 begins with the
Volume 3.
Constitutional relations between Britain and India.
Yes, yes. May I please it? Hello, the Chief Justice.
Yes.
Please read below the caption, section 5 of the Act. A revised draft.
Where do we, the page 327 is the title page.
Next page, please. Page,
Next,
running page 70.
that is 8 June 1947.
The letter of 8th June
Mr.
1940.
Rajgopalacharya to Sir S.
No, Lordship, go ahead. That's, I'll come to that letter later, please. Please come to running page 73. Oh,
Where is Mr. Kanu Agarwal?
sorry, PDF 334.
PDF
334, I'm so sorry.
334.
Achha. All right, then got it.
334 is a part of some document, I guess. What is that document that this is a part of?
Oh, that's some earlier
It's
letter, Lord.
enclosure number 1 to number 111. The disappearance of paramountcy, the emergence of independent sovereign states, and the balkanization of India by Sir Allah.
PDF 345.
345. 1 second. Give us a moment.
Three, four, five meetings of the Indian cabinet.
Yes, yes, meeting of the Indian cabinet. I'm grateful. May I place that, please? Meeting of the Indian cabinet.
Yes, 345. Actually, this is a part of volume 12 of the transfer of transfer of power documents. And now we have
Oh, hell, you be told.
page 345, which is meeting of the Indian cabinet,
That's right. May I place it?
Mountbatten papers, Indian cabinet minutes, part 2.
Yeah, the Indian Provincial Constitution Order 1947 was being discussed. The Honorable the Vice President recalled that in the discussions at the previous meeting of the Cabinet on the India Provisional Constitution Order 1947, two sections, namely Section 5 and 47, had been left over for further consideration. Section 5. A revised draft attached, prepared by the Reforms Secretariat in the light of the previous week's discussions in the Cabinet, was handed to the honorable members. It was pointed out that there was the same fundamental objection to the draft as now revised as to the originally redrafted Section 5 of the Act considered at the previous meeting. The draft gave the impression that the dominion was limited to British India, which was an entirely wrong conception. It was necessary to devise a formula to show clearly that the dominion of India would comprise A. Governors' provinces, B. Chief Commissioners' provinces,